My name is Micah Smith, and I, along with Kate McMahon and Amanda Stranos-Walker, will be presenting the webinar this afternoon. So we do have the option there, if you're logged into the system, that you can ask questions. We will try to flag questions, probably answer them toward the end, but feel free to ask them during the conference. So without any further ado, we will get started. This month we're talking about OSHA and the status under the Trump administration. There's been a lot of talk. We certainly talked about it ahead of time with before the election even, wondering what would happen under a Trump administration for OSHA. We've talked about it again more recently after the inauguration, and now that we're about 6 months in, we wanted to circle back, see which of the tea leaves we had read correctly, which of them we may have missed, and so that's what we're going to do here. I'll quickly introduce you to the presenters. As I said, we have Kate McMahon. She is a partner here. Kate, do you want to introduce yourself briefly?
Certainly. Good afternoon, everyone. It's good to talk to you all today about this fascinating topic about what's happening in the new OSHA under President Trump. Lots of interesting information, I think. Just very, very briefly, for those of you who have not listened in on webinars that I've given in the past, I have long history in this area, working in the regulatory area with a particular focus on chemical rulemaking and OSHA's rulemakings in general. I have spent more years than I care to admit focused on OSHA's Washington, D.C. efforts in the rulemaking area, as well as in major enforcement actions. And so I'm here to talk to you about what we're seeing from the inside the Beltway perspective. I think, just to start out, I will say that I think there's a lot still that we don't know, but we'll get into that later. Let me pass the baton to Amanda Stranos-Walker, who is also with us and a partner of ours at Conn Maciel Carey. Amanda, do you want to introduce yourself?
Certainly. Good afternoon. My name is Amanda Walker, and for individuals that have not joined one of the webinars that I've been present on before, I've been part of the OSHA group at Conn Maciel since its initial founding back in 2014, and my primary focus is occupational safety and health. And before making it out to private practice to represent individual employers, I actually started on the other side, working at OSHA in the front office and then in the solicitor's office. So finding it very interesting with regards to the changes that are happening in this administration, and look forward to talking to you more about it.
All right, and last and certainly least, I am Micah Smith, and I am a more recent addition to the firm of counsel here, and as you can read on the slide, we do all sorts of things for our clients, all focused on OSHA. So we'll go ahead and not waste any more time. We'll get started. So here's a quick look at our agenda today. The real focus today will be, of course, on what actions have been taken by the administration. As everyone probably knows that's following this area with any rigor, you'll know that we don't yet have a confirmed assistant secretary to head up OSHA. But even without all of the appointees in place, there's enough information here that we can start to actually draw some conclusions about what's going on. So we're going to talk about some executive orders, the regulatory repeals and delays, a couple of the specific rules. Interestingly, we've now had time to have a regulatory agenda, so that gives us some signals about where things are going. We'll talk a little bit about the budget. We don't have a budget actually passed yet, but we've seen a couple proposals. And last, we will cover what we think will be the future of OSHA enforcement. So digging right in, I'm going to kick things off on the deconstruction of the regulation. So as everyone who's been paying attention knows, we've seen a lot of efforts to talk about reducing regulation, trying to get government out of the way of the private sector. I think the most obvious, the strongest statement that we've seen from the administration in this regard was from Steve Bannon back in, it was probably February or March at the CPAC conference. He said, he put it right on the nose, said, look, we're looking at the deconstruction of the administrative state. If you look at the cabinet appointees, they are all in line with the deconstruction, right? So it's a very clear statement from his mouth about what he thought the government was doing. It seems to match up well with President Trump's campaign statements as well, right? Try to get the government out of the workplace, let states take the lead more, and repeal what were characterized as certainly overbroad or overly restrictive rules that were promulgated by the Obama administration. So keeping that in mind, that we've certainly had these broad statements and these statements during the campaign that tend to frame the issue, but there's always the question of you stated a grand strategy or a grand idea. Will your specific actions follow through with that? And so as we look at some of the actions that were taken, we'll see that they have so far. Probably the most important and potentially most controversial executive order that relates to this area is 771, or as we refer to it more casually, the 2-for-1 executive order. So here, there's a lot of detail to it, certainly as enacted, but the baseline is President Trump has said if an agency wants to promulgate a new rule, they're going to have to get rid of 2 other rules. That has to do with both the number of rules, and it also has a cost element. So as you see on the slide here, the agencies have to ensure that the total incremental costs of the new regulations are offset by repealed regulations. So this order was issued, I think, in January, and it took a while for us to have any idea about where things were going to go with it. We didn't get guidance on this until April, when OMB issued their first guidance on how the agencies were to implement this executive order. If you want some good reading, the OMB guidance, I think it's 12 or 13 pages long. It's pretty dense, but if you're enough of a regulatory nerd like me, you might find it enjoyable to read. But we'll give you the highlights here. What regulatory actions have to be offset? I mean, that's the real question. Our earlier webinars that we had talked about this and speculated about where this might go, we said, what's a new rule? What agency actions are going to have to fit under this? Because, of course, if you set a very high bar for actions, then this 2-for-1 rule order wouldn't have much effect. On the other hand, if you try to apply this to every single agency action in every agency, you could see some real problems related to workability, whether it relates to things like fish and wildlife and hunting permits and fishing limits and things like that. You could see how it'd be a real challenge to try to keep the government running while also reducing the number of regulations. So the OMB guidance was pretty useful here. It said, basically gave us 2 categories of regulatory actions, and the focus is on significant. So there is a significant regulatory action. This tends to be rulemakings, though there are a couple of other small categories you can fit into there. The other one is a significant guidance document. So it captures both actual rules and then also what we saw during the Obama administration at times where agencies using guidance or issuing guidance and altering a rule in a pretty significant way, such that there were several that were challenged as being actually rulemakings instead of guidance, actual guidance. So here are the 2 big categories. Those are the things we have to worry about. Now, with this seems to be a fairly broad definition, right? The question, though, is how will this play out? And as we've watched things develop, I believe that there's only been one regulatory action that has been flagged by OMB as qualifying under this 2-for-1 scheme. I think it was the Waters of the U.S. rule from about a month ago. So we have these pretty broad definitions of things that fit under the 2-for-1 regs, but so far we have not seen a great deal of a great number of agency actions flagged. It could be that we just are not seeing a lot of agency actions because the executive departments are still being filled out with the political appointees. That may be a factor. It may be that there's something else going on. We'll have to keep watching this. All right, so that's the one side, the regulatory actions that have to be offset. Deregulatory actions. What can you do to earn these offsets? There's also a pretty broad description here of what you can use. You can use informal or formal rulemaking. You can use guidance. You can take actions to streamline record-keeping, reporting, or disclosures. And those are the real big ones. So we're looking at actions that will reduce the impact of the government. Also of note, if there's both a rule element and a cost element, you can, of course, for each of these rules, you're going to be, the OMB and the agencies are going to be looking at the costs. What's really interesting about this is that the OMB guidance makes it clear that agencies will be able to bank their cost savings or bank their deregulatory actions. So, for example, if this year OSHA wants to promulgate one new rule, but they manage to issue 3 deregulatory actions, they can hold over that credit for the extra one until the next fiscal year. Same is true for costs. Last thing that's important here are what kind of things are exempt from this. So there might be significant rules, but that are not expressly included in this. We've got a couple categories here. There are expressly exempt actions. These tend to focus on the military or agency actions taken for the purpose of national security. And then there are 2 other categories, emergency actions and statutory or judicially required actions. So these are included, and I believe that this is essentially an attempt by the OMB to make sure that this executive order stays within the bounds of what's the executive is legally allowed. What's interesting about it is that this allows agencies to take emergency actions or to pursue statutory or judicially required actions without considering these offsets, but the OMB will require the agency to later on come back and actually do an offset. So they get to skate by for now, but they will have to make it up later. So I think that's going to be something interesting as we see how these agencies function. This, as you might have expected, this executive order was challenged fairly quickly by interest groups. I believe the lawsuit was filed in February. We've since had a motion to dismiss by the defendants and a motion for summary judgment by the plaintiffs. That was argued last week, and you know there are a couple of news stories about this. You can see some of the comments from the judge. I think that Judge Moss asked some good questions of both sides. His questions for the plaintiffs focused on whether they had standing to actually pursue this challenge, and then the questions of the government focus on what was really going on behind the scenes and whether the public would be able to know whether agencies were pursuing these rules, did deregulatory actions of their own accord, were they sacrificing rules so that they could pass a rule that they really wanted, and so his questions tended to focus on that and the administrative difficulties of all that. All right, so that's a 2-for-1 rule executive order. You probably also remember back from January or February, Executive Order 13777. This was the order that established the regulatory reform task forces. We have not seen a lot of specific developments from these. There have been a few news articles that have talked about the people that are involved in these task forces. But so far we haven't seen a lot of action from them. So at this point, we know that the task forces are meeting. We know that they're pursuing their missions as assigned in the executive order. But so far, we have not been able to tie any agency action to these task forces. Again, this may be because the political appointees are still getting in place in these agencies, or it could be that it's just going to take a while for this to move forward. All right, so we'll do a quick run through some of the regulations that have already been repealed or delayed. The biggest tool probably that OSHA has used in the deregulatory effort was the Congressional Review Act. You may have remembered several times early on in the administration, Congress was acting, trying to get rid of these midnight rules. As we have here on the slides, the Congressional Review Act was passed in 1996 when Newt Gingrich was Speaker during the Clinton era. Interestingly, it was only used once during before President Trump was inaugurated. That was at the beginning of the Bush presidency to get rid of the ergonomics rule from OSHA. However, despite its minimal use previously, in the Trump administration and the current Congress, we have seen heavy use. There were 15, well, there are multiple raised, and 15 that were seriously moved forward. 14 were signed by the president. So we have a 14-fold increase over any previous use of the CRA up to this point. Of note, the two OSHA regulations that were repealed were the Volks rule and the FAR rule, and we'll cover those in slightly more detail now. But that was a pretty big effort across the government to deregulate and really to walk back a lot of the things that had been pushed out during the Obama administration. All right, so here are the big changes under OSHA. You've got the Volks rule. If you've been following along, OSHA, of course, has record-keeping rules that require employers to keep records of injuries and illness. It's long-standing requirements. OSHA had, over the course of time, the rules include retention requirements, that you have to maintain these records for 5 years. OSHA had gradually begun to interpret this retention requirement such that it allowed them to issue citations to employers for the entirety of the 5-year retention requirement. That presented an interesting conflict with the OSHA's very short 6-month statute of limitations. But we saw that condition continue for quite a while up until the Volks case came through the commission and the courts. This was in the late 2000s, I believe. I don't think we have the date here when this happened, but it was 2010 or so. There was a D.C. Circuit decision where the court held that OSHA could not use their retention requirements to extend the statute of limitations for citations to be issued for record-keeping violations. This is a big blow to OSHA, where we really saw their ability to issue record-keeping citations diminished because they basically had to show up, find the violation within the first 6 months of the misrecording in order to issue a citation. So that was a big move, but under Obama's OSHA, they promulgated a new rule, informally called the Volks rule, to change that, to turn that back, and to write into the regulation that there was try to get this 5-year retention requirement to more officially allow them to issue citations. That was published in December of 2016, so it fell into the category of one of these midnight rules, which enabled this Congress and the Trump administration to use CRA to overturn that. So as a result of this CRA action, we are now back in the post-Volks decision, pre-Volks rule issued by OSHA. So now OSHA, for record-keeping violations, has 6 months, a hard 6 months, to issue citations related to record-keeping. This certainly has a significant effect on citations because, as we saw post the D.C. Circuit's decision in Volks, OSHA's record-keeping citations dropped by 75%. So it certainly has a significant effect. One last one to talk about here is the FAR rule, and I'm going to pass this over to Kate to talk about that.
All right. Well, continuing on with the story that Micah is laying out about the use of the Congressional Review Act, and I think Micah may have stated at the outset of that discussion that, you know, this was a little used tool once before on the ergonomics rule, but other than that, it had never been used in any prior administration to void a rule. So now we have the Trump administration using it twice right here out of the gate. And the second rule that was subject to the CRA was, as Micah said, the Fair Pay and Safe Workplaces rule. That was a rule that many of you may be familiar with. Eric Conn, our venerable leader of our OSHA practice, and I worked with a coalition of companies, some of which I think are on the phone today, to address the concerns that industry had about this rule. It was gigantic. It was had massive implications, and it was not a traditional OSHA rule. It was actually a rule that was promulgated by the FAR Council, and the Department of Labor issued guidance that essentially interpreted what that rule meant. The rule, in a nutshell, basically required companies that were contractors or subcontractors with the federal government to report on a essentially continuous basis every 6 months any alleged violations of a series of 14 separate laws or regulations relating to the Department of Labor and labor standards. So that would include, of course, the wage and hour laws, EEOC, FLSA, and of course OSHA, which is why we were involved. Those reports would have to be of citations issued, regardless of the outcome of the citation, even if it were completely withdrawn. So, needless to say, a lot of the industry was very concerned about this rule. It doesn't surprise us that it made the cut for the CRA because of the huge support or huge opposition, I should say, of industry to the rule. The Trump administration listened, and the Republican Congress listened, and on February 2nd, there was a joint resolution passed by the House to void the rule, followed on March 6th by a joint resolution passed by the Senate to void the rule, and then those resolutions were passed into law by President Trump on March 27th. He signed the rule eliminating the FAR rule. So the blacklisting rule, as it was, quote, affectionately, unquote, referred to by industry, is now gone. Now, one note that I want to just make sure we're not saying anything that is misinterpreted. Pursuant to contracting laws that had long been in existence, responsibility determinations continue to be part of the federal, contracting bidding process. But what was eliminated by the CRA of President Trump was this new FAR rule that required this proactive reporting of all labor-related violations and alleged violations. All right, so those are the CRA actions. Now, what else has been not deleted, voided, eliminated, but slowed down, leading to some real question about whether these rules will ever be put in place and implemented. Let's talk about the other action that President Trump took out of the gate to impact the regulatory state, if you will, in our area of focus, OSHA. So as many of you probably know, on January 20th, the day of inauguration of President Trump, his, I guess now we say former Chief of Staff, Reince Priebus, issued a memorandum that was directed to the heads of all executive departments and agencies. And essentially, that memorandum did really sort of three big things. One, it told the agencies to halt submitting any regulations for publication in the Federal Register, regardless of how far along they were, until an approved Trump-appointed principal or someone that a Trump-appointed principal delegates has an opportunity to review those rules. So, you know, regardless of how close a rule was to being finalized, the message from this memorandum, the directive from this memorandum was halt, stop, don't go any further till someone in our new administration can review. Second, for those rules that were further along, that had basically, they were, you know, what we'd say are in transit. You know, I always picture the, you know, when you'd go pull up to the drive-in window of the bank and you put your check in the little tunnel and it's being moved over to the bank to be cashed. Well, you know, we're talking about those rules. They're done. The Obama administration has finished them. They have been submitted to the Federal Register for publication. The message, the directive from the previous memo is halt and withdraw those regulations that have not yet been published in the Federal Register. And third, where possible, the previous memo directs agencies, including, of course, OSHA, to postpone the effective date of any rules that have already been promulgated and published in the Federal Register, but for which the effective date has not yet come to pass. So for those rules, hold up, let the administration take a look at those rules. And in fact, the memo gives some meat to what this looking at is going to do. The memo basically says, give us this time period, this 60-day time period, and by the way, it also says extend that to the extent necessary, to allow us to review questions of law, fact, or policy, policy being the big one of those three, I think, so that this administration has a chance to decide whether they agree that a rule that had just been promulgated by the previous administration, but the effective date had not yet come to pass, ought to go forward. Now, query, and we're going to talk a little bit about this, query what it means. If the law is on the books, it's been promulgated, it's a final rule, there's no effective date yet, but there's an effective date in the regulation that's, you know, about to come. What happens to those rules? Can they just be, you know, can the administration say, oh, we don't like those, what do we, you know, so they're gone? No, there's a law, you know, there's a rule of law that is important here. And the new Secretary of Labor, I don't know if we have this on our slides or not, but Alex Acosta in his confirmation here published a article in the Wall Street Journal where he stated that, you know, regardless of our policies, we have to follow the rule of law. We are not just going to willy-nilly, essentially, I'm reading between the lines, but he's saying we're not going to just willy-nilly vacate, get rid of, or not follow the law in changing our regulations that are on the books. And that was, I think, a heartening message to the left because there was a lot of concern that that would not be the case in this new administration. So let's apply the previous memo and the other mechanisms that might be available to this president to real live rules that had been promulgated late in the administration, and let's talk about what's happening with those. The three that we think are most sort of prominent for a number of reasons, not the least of which is because they're very significant rules. They will have a significant impact on the stakeholders and industries that are implicated or affected by these rules. Two of the three that we're going to talk about have wide-ranging, very broad application to millions, can I say millions of employers, so certainly millions of workers. Let's talk about those and do a little deeper dive on those. We have a slide here that identifies 3 rules that were promulgated late or late-ish in the Obama administration. The electronic record-keeping data submission rule, and we'll talk in some length about that because I bet you many of you on the telephone today are impacted by that rule or potentially impacted by that rule if it stays around. And then 2 chemical standards, the silica and beryllium standard. Let me talk about those first, and then we'll go back to the electronic rule, injury record-keeping rule. Silica and beryllium. As many of you may know, the last administration under Dr. Michaels was very focused on methods and mechanisms to update chemical standards. And I'd say that even Dr. Michaels would probably say that there was a huge failure on the Obama administration's part to actually get that done. We did see, though, a few individual chemical standards that were updated. The 2 prominent being, in fact, I think maybe the only 2 in this administration, being silica and beryllium. Okay, silica, hugely controversial rule, promulgated in March of 2016, and this webinar is not about the details of these rules, just sort of what's happening to them, almost by way of example of what we might expect going forward. But bottom line for silica is we had a rule of huge significance and also long in the making. I mean, I have seen a film of Frances Perkins, the first Secretary of Labor, holding up a book, 1 to 2 inches thick, that is a study on the dangers of silica from the 1930s. And that was the first marker of when the Department of Labor, well before the OSHA Act existed and well before OSHA existed, when the Department of Labor first started concerning itself with the exposure of silica to workers. All right, so one could say that this rule has been in the making since the 1930s, but certainly actively in the making since the early 2000s. Finally promulgated in March of the last year of the second term of the Obama administration. Where does it stand? Well, first of all, as I'm sure all of you know, or many of you know, the rule was immediately challenged by a horde of industry petitioners who have claimed that, I think the bottom line is, while it may have been necessary way back when, in the day of Frances Perkins, technology has evolved. Basically, this rule has been challenged on all fronts. Significant risk, technological feasibility, economic feasibility. All right, so broad-ranging legal challenge. That is sitting out there right now. The case has gone forward. It has been fully briefed, as I understand it, and it is awaiting oral argument. So there may be a judicial, fix here to this rule if you're looking at this from the Trump administration. But in the meantime, of course, there are compliance dates that were set to kick in. The rule applied to all 3 of the industry sectors: general industry, maritime, and construction. The first compliance date that was set to kick in here was set to be June 2017. In April of 2017, brand new administration, and interestingly, without any any Trump appointees, political appointees in place at that point, the OSHA, the sort of sitting duck waiting for the next bosses to arrive, OSHA, decided to issue a memorandum delaying enforcement of the construction standard date that was just about to be triggered a couple of months later. I'm being confusing here. Let me try to clarify. The rule applied to all 3 industry sectors. However, there were staggered rollout dates that were into the future. The first implementation dates that applied for general industry and maritime were not set until June 2018. Okay, so we still have a year to go, or almost a year to go for those. But for the construction silica standard, the date was June 2017. That is the date that the administration, without a Trump appointee in place, delayed until September 2017. So we're sitting here on the edge of our chairs waiting to see what might happen with this date, because this September 17th implementation date, compliance date, because the court case most certainly will not be resolved, or at least in all likelihood will not be resolved prior to this first implementation date. We now have a political appointee in a position over at OSHA, and so we're waiting to see if an additional delay is issued to the construction standard. That's the status of silica. Bottom line, there's no existing compliance that has to be done for silica. Beryllium, not as complex. It's a much smaller rule in the sense that it applies to a much smaller segment of workers. I think the estimates maybe are something around 40 to 60,000 workers versus, I want to say 2.5 million, but I could have that wrong. In any case, a whole bunch for silica. But nevertheless, a very critically important rule, and a rule that was established in an unprecedented agreement between labor and industry. However, and the rule, by the way, was promulgated literally just weeks before the Obama administration left office. It came out, I can't remember the exact date, but I think January 9th or something to that effect, before the inauguration. This rule was not the same rule as the unprecedented coalition of industry and labor had proposed to OSHA. The agency had made changes to the rule, some of which industry believes had a very significant impact on its breadth and on its requirements. So this rule, too, has been challenged by industry and is in the process of being litigated. Interestingly and very tellingly, I think, this administration, again, before any political appointee actually arrived in the front office of OSHA, decided that they would pull back a very significant part of the beryllium rule. The beryllium rule, as had been proposed by this coalition of labor and industry, applied to just general industry. But when OSHA promulgated it in final form in January 2017, weeks before the Obama administration left office, it covered the maritime and construction industries as well. The new proposal that was just recently issued by OSHA, on which industry is commenting as we speak, deletes those, the application, if you will, to those sectors. The maritime sector and the construction sector would no longer be covered by the beryllium standard. This is done by OSHA sua sponte, essentially, although certainly requested by industry. And so we will see, except for the Pell. They've left the Pell in place like a Table Z limit, but everything else is proposed to be gone. It is likely that that will be the outcome, notwithstanding the fact that, of course, labor is vociferously opposing this. All right, the electronic record-keeping standard. I've sort of scooted ahead, so yeah, let's move up through these slides. I don't have, let's see, we're kind of running short on time. So let me give you the highlights on the electronic record-keeping rule. The electronic record-keeping rule, as many of you know, has two separate components. One component, which requires, for the first time ever, employers that are covered by this rule anyway, and that shows up on this slide in front of you, to submit their injury and illness log data that has historically been kept private and in their custody to OSHA through this portal that the agency created, And separate from that requirement is another part of the rule that is referred to as the anti-retaliation provisions of the rule. Let's talk about these separately. As to the electronic record-keeping part of the rule, another delay. We had originally, under the Obama administration rule, the portal was set, well, let's move ahead to the next slide. Why don't we do that? We had, the rule had established certain deadlines, all right? And they were staggered, 2016, for instance, establishments with 250 or more employees had to submit their 300 A's by a certain date. It was July 1st, 2017, a month and a half ago. Establishments with 20 to 249 employees had to submit their 300 A's by that same date, all right? This administration changed that date and delayed that requirement. Now, no one has had to submit any of their logs, not their 300A logs, nothing. And the new date is December 1st, 2017, as you see in this updated slide, all right? The big question is, we're in August now. Just like silica and beryllium, there's an industry and challenge out there. We'll see what happens with those court cases. But the question is, will this administration further delay that requirement? And implicated here, of course, is the state plan states. What are the state plan states going to do? And I'll talk about that in a minute. The delay, as you see on this next slide, that was issued by the agency in June, said that, and it was done in the form of a notice of proposed rulemaking, it said that the delay was designed to allow the new administration time to decide basically what it wants to do with the rules. So we don't know yet what is going to happen. However, it is very prudent to note that the agency has moved forward on this rule because it to the extent that it has set up this live portal. This data has to be submitted through this portal, this electronic portal, and the agency moved forward and got that set up. It went live on August 1st. Voluntary submissions can be sent in. There's a whole protocol to submit your data. All right, live and breaking news that Amanda Walker, who's going to talk in just a minute, just gave me literally before we got on with you all. As of about 11:55 a.m. today, or about noon today, an hour and a half ago, interestingly, if you go to OSHA's website where you would find the link to the portal, it's gone. It's taken down. We don't know why. It could simply be some sort of technical issue. I mean, this is, it is a government, a government-run program. No offense to the government, but these things happen, right? So it may be that there was some technology issue and it was taken down temporarily to fix that, or it went down inadvertently, or you don't have to be too paranoid or joyous, depending on your perspective, to wonder whether this was an intentional takedown of this portal, and that may be a sign that the agency is planning to do something that would, further, sort of pull this rule back. Meantime, there are legal challenges going on. The challenge on the electronic piece of this rule, the electronic submission, is in the Western District of Oklahoma. Status of that is that we have it has stayed pending, further action by this administration, and there has been an intervenor motion that was denied. The labor industry, certain labor groups, moved to intervene, saying basically that they did not think that the Trump administration was going to defend this rule, so they wanted to get in. But the district court denied that. All right, just very, very briefly on the anti-retaliation component, That component, too, is in, there's a legal challenge that's been filed. It's in the Northern District of Texas. That case has also been stayed, and there's also been an intervenor motion, interestingly, filed by Labor, too. That one has not yet been ruled on. It's been stayed, so the court said we're not going to rule on that at this point. That rule, unlike everything else, is actually in place. There has been not been a stay of enforcement, and it is in place and being enforced. As far as we can tell, the enforcement is happening. It isn't that the agency is just sitting back not enforcing it, but it looks to us, based on the anecdotal data that we've gathered, that it's being enforced only where there's an aggrieved employee who has raised this issue. So that's the status of that. We expect that this portion of the rule, because it is highly controversial, I'd say probably even more controversial than the electronic submission, that portion of the rule will be dealt with by the Trump administration in some form or fashion. And then I guess the final thing I'll say about this electronic rulemaking is that the plan had been, under the Obama administration, to take this data as it comes in and publish it live on OSHA's website, make it available to the public, to unions, to market competitors, et cetera. The Trump administration, OSHA, has indicated that it has no intention of publicizing this information. So that's basically the high-level review of that, of where sort of some key rules that were promulgated at the tail end of the Obama administration now stand. All right, with that, let me turn this over to Amanda, who is going to talk about the Trump administration's first regulatory agenda and the budget that we're looking at for OSHA under the Trump administration.
Thank you, Kate. Talking about the first, Trump's administration's first regulatory agenda, just a little background. Regulatory agendas are, I think, actually required by executive order. They usually come out twice a year, no matter who sits in the president's office. And actually, this one was a little delayed. They usually come out in the spring and the fall, but as you will notice on this first slide, the first regulatory agenda published under the Trump administration came out in July 20th. That happened to coincide with the confirmation of the OMB, the highest political at OMB. OMB is kind of the organizing agency within government that handles the regulatory agenda for all the federal agencies. So it's just not specific to OSHA, but it applies to all agencies. And what's so interesting about this, it gives you a roadmap. It's to give and notify the public on what rules the administration or government in general is working on, and just keeps you informed and where you can provide comments if need be. Kind of the background on it. And we did, usually in the first, when you see a change in political parties in the White House, the first regulatory agenda can be somewhat enlightening, and you can see a big reshuffle, which is kind of what we've seen here with this July 20th agenda. Removed rules, I don't think anybody would be terribly surprised or was surprised to see some rules come off the previous regulatory agenda that had been published by the Obama administration. And those rules that did come off, here are some more of the substantive ones. The comprehensive rule addressing combustible dust. This has been a rule that's been on the rulemaking agenda and the agency's been working on for probably 10 years. It's a very complicated rule, covers a lot of industries, issues with feasibility and what is technically feasible as well as economically feasible. That came off the regulatory agenda on July 21st or on July 20th. Another rule that came off was the updating of various PELs. OSHA has this long-standing issue with updating permissible exposure levels. A lot of the PELs that are currently in effect came in when OSHA started to exist in the 70s, and it's a very rigorous, long process for updating these PELs, and they were looking for alternative ways to update them. This is another issue that came off the regulatory agenda. And then there was two construction-related issues that also came up, hearing protection in construction, as well as backing up hazards, basically equipment and backing up, pinching people or putting them up against a wall or something like that with regards to injuries. So those were all of the rules that were removed from the regulatory agenda. Now let's talk about some of the rules that were, once again, on the Obama regulatory agenda, but were kind of downgraded or shown that they have a less of a priority in this administration by moving it to the long-term actions, which is another category that you can have in the regulatory agenda. These are basically considered to be rules that are still being worked on, maybe not the highest priority rules, but they still have some activity and they still exist on the regulatory agenda. Some of the rules that we saw move to the long-term category was workplace violence and health care. This was a addition to the regulatory rulemaking agenda in the final weeks, maybe the final month of the Obama administration, and it really dealt with when you have nursing homes or psychiatric long-term health care facilities and some of the protections that would be eligible for health care workers. Another issue that was moved to the long-term actions was reforms for the PSM standard. Under the, I guess after the West Fertilizer incident happened in 2013, President Obama sent out an executive order indicating that there should be a review of regulations pertaining to handling and control of highly hazardous substances. OSHA engaged in a SBREFA process with regards to this, and that issue has now been pushed to the back burner. We also had emergency response and preparedness, and also infectious disease and healthcare. That again would be like your SARS or tuberculosis in the healthcare industry. So it was a specific rule, and all of these, like I said, are still on the agenda, just not getting the same level of attention that they might have gotten last December, November, that time frame when the previous administration was in office. Some interesting aspects about what we did see on the rulemaking agenda or the regulatory agenda that came out. There was actually some additions. Didn't necessarily think that we would have additions this early in the process, but one of those additions, and if there was an addition to be had, I guess it's not altogether this surprising that it was with regards to the electronic record-keeping rule. Kate talked a minute ago about this rule and the electronic submission component of it, as well as several other components. So this was a rule that was promulgated and finished in the last administration, Dr. Michaels in the Obama administration, and it was published really on the cusp at the end of their term, sometime in, or actually it might have been earlier, but it did not take effect until this administration came into office. Might have actually been May of last year when it was published, but it was not set. The first provision to take effect would have been with regards to the electronic rulemaking in June of this year. And when this administration came in, was kind of, there was a review process underway, and some deadlines got extended, and there was a notification published with regards to the electronic the electronic injury and illness data submission requirement. So this was also put on the regulatory agenda, proposing the deadline of now December 1st, and also taking general comments on the electronic submission. Some things that, as Kate mentioned, that we're likely to see as a result of this rulemaking might be, cutting down on the amount of information that is going to have to be provided by employers. Maybe it's just going to have to be the 300A, which was, previously there was a program that OSHA sent out notices to certain employees to conduct a survey, and employers would have to provide that information. Maybe they're going to take that survey electronically, and basically what they had collected before was information on the 300A, the annual summary. Maybe they're going to require submissions with that and scrap the requirement to submit the actual logs, the 300 form and the 301, the incident forms. So that's something that could be possible under this regulatory rulemaking provision. And then there's also the second issue, and then here we list several of the other things that we could see here, revisions to the rules, the scope of the injury data required and submitted, some variations in the DART rates, and the threshold employees to be covered by the standards. All of these things would bring down the actual number of employers required to submit information. They're also working with regards. Hello, am I still here? I've just got a funny beep on my line. And with regards to eliminate or cut scope, the anti-retaliation provisions within the record-keeping standard as well. Another surprising aspect of the regulatory agenda was to see 2 LOTO regulatory actions on there. And these regulatory actions were kind of contradictory. One was kind of a change or a technological advancement in new upgrades that have been brought to the marketplace since the LOTO standard was promulgated. It's currently in the pre-rule stage. This is a new addition. It's something that was not on the previous regulatory agenda. And they're currently in the process of collecting comments on how it would work, how effective it is, and the potential hazards of permitting it. The other one was something that was on the previous regulatory agenda and was somewhat surprised to see it there continued on the agenda. It was kind of hidden under a standard improvement project, but it's basically modifying the current LOTO regulation to deal with some cases that found that LOTO was not applicable in cases where you did not have unexpected energization. And in those cases where you have a machine or something that gives a clear, audible, timely warning to notify employees before it re-energizes, gives them enough time to move away from the equipment so that there's no hazard. The courts have found, the Sixth Circuit in particular had found that in those instances, the lockout tagout standard did not apply because it was not unexpected energization. OSHA in the SIPS rulemaking or updating, which SIPS is typically intended for non-controversial aspects, and it came out of a Clinton-era executive order that you're supposed to go back and look at your regulatory rules, update them, make technical amendments, and really not intended to address anything that is controversial. And so this rulemaking to take out the unexpected aspect of the energization out of the lockout tagout rule was slipped under there, and that is something that did continue on the regulatory agenda. So that was somewhat surprising. Let's see, other rulemaking activities that are still on there, a new standard addressing communication tower safety. This was something that was started back in 2015. The next step, they collected some information with regards to this, and the next step is the SBREFA process. I think it was tentatively posed to start in August or September. It's not unusual for there to be a delay with the dates that are put out in the regulatory agenda, and as far as I've heard, they've not indicated that they're going to be starting the SBREFA at this point. An update to the powered industrial truck standard. The PIT standard is something that is based off of a 1969 ANSI standard, so a little outdated. Looking at updating that based on new ANSI standards. When the rule originally came out, I think there was 11 types of powered industrial trucks. There's currently 19. So looking at potentially updating that. And then the other one that was also on the regulatory agenda was an update to the standard for mechanical power presses. This is, once again, an older regulation that came in the early 70s when OSHA had the authority to adopt industry standards without going through rulemaking, and now looking at making updates to the regulation. There's certainly been updates in the industry standard that it was based on. So turning it back over to Micah to close us out.
All right. Amanda, are you, we have a couple slides here on the budget.
I'm sorry, the Trump budget. I'm sorry, I was thinking that I was done, but I am not. Turning over to the OSHA Trump budget in the Trump era. I think that there was a initial thought that the OSHA budget might be significantly slashed under this administration, and when we started to get the thin budget that came out earlier this year, probably around March or April, I think that, there was an indication that that was not going to be the case. The Trump budget came out a little bit lower than what it had been in the Obama administration, but that could be largely related to some cuts with regards to training grants. Susan Harwood training grants. This has been a program that's existed within OSHA where they give money out to providers to provide training for a number of years. I can remember it being controversial when I was back in the agency in the mid-2000s. It still continues to be a controversial training grant program. The Trump administration budget, both the skinny budget and the fuller one that was released later, proposed cutting those. One thing we did not see was an impact with regards to the Trump budget with regards to enforcement. Pretty much stayed as is. And just an interesting note in the safety and health context that there was the Trump budget proposed defunding and basically abolishing the U.S. Chemical Safety Board. So far, it seems to the House budget, moving on to the House appropriations, they did keep the Chemical Safety Board, but they did actually take a little bit more money away from OSHA than what the Trump budget had proposed. It was about $21 million less than what was in effect in fiscal year 2017 and about $12 million less than the Trump budget proposed in 2018. The other interesting note in the notes with regards to the discussion or that came out of the House Appropriations was, a strong focus on compliance assistance, more effectively balances enforcement with education, training, and compliance assistance, giving a direction or a message to the agency that that's where they would like to see them go. I think that's consistent where we're likely to see the administration go, but just further reinforcing it. This House Appropriations Committee budget was passed in late July. Its next stop will be the full House, and I don't think that there's a date set for that. And then also on the other side of the chamber, we have the Senate, and they have not had their budget markup at this point. I don't believe so. So, and after you have it on both sides, then there'll be a reconciliation of both budgets before we have a final one. Now, officially turning it over to Micah.
All right, thank you, Amanda. All right, we are running out of time. I'm going to run the last few slides fairly quickly. We've talked about a lot of this before, so we'll keep it brief. The last piece is enforcement, right? You can have all the rules in the world, but it's when they get enforced that really hits you where you live. So what do we expect to see? Certainly when the Obama administration came in, we saw a real uptick in enforcement, or uptick also in rulemaking, but also a lot more enforcement. We expect, as we probably would have under any Republican administration, that there will be some amount of scaling back, that we will not be quite as enforcement heavy. We think that there will be a rebalancing toward compliance assistance to a program that really got the short shrift during the Obama administration. We think that part of this will relate to the VPP program, that they will see OSHA trying to work more with the high-performing employers. And then we probably can expect some changes in the field operations manual or enforcement policies. Unclear, we haven't seen any real moves in that direction, but those are the kind of things that we're looking for that will signal where the administration will be heading under the enforcement side of things. We'll skip over this fairly quickly. Another big change we might see is the OSHA under Trump moving away from using repeat citations as much as they had previously. During the Obama administration, they had changed the look-back period from a 3-year look-back to a 5-year look-back. It would be pretty simple to change that back to a 3-year look-back. we'll also expecting potentially OSHA under Trump to rely less on looking at all work sites as work sites under one corporation as one workplace. That's one way of really ratcheting up the pressure under repeat citations. So I think we can probably expect to see a little bit less of that. And then we're also expecting to see a little bit less of the proactive targeting. If you get citations at one facility, historically there's a fairly low likelihood that you would get another visit from OSHA at that exact same facility. We saw that change somewhat during the Obama years. We think that will probably flip back the other way. As you can see in the slide, we saw a tremendous increase in the percentage of repeat citations that were issued over the course of the Obama administration. We're expecting to see that change and drop back down, but we'll see where we go. And so we've already covered this here. Another big initiative under the Obama administration has been this regulation by shaming, and we're expecting to see this change and that press-heavy enforcement model to be rolled back. We hadn't seen any official actions, but in the early days of the administration, most agencies across the government had been encouraged or required to reduce their press activity. So it was unclear whether that was going to be temporary or not. As with all things, without the permanent OSHA team in place, we're still reading the tea leaves a little bit, but I think it's worth noting that in June and July of this year, we saw 2 or 3 enforcement press releases issued, whereas in June and July of 2016, the last year of the Obama administration, we saw per month somewhere between 25 and 40 enforcement press releases issued. So at this point, we are seeing some enforcement press releases, but certainly not at the level that we were seeing under the Obama administration. All right, so skipping ahead, and there's some numbers, and I think that even puts the point on it even better than the way I said it. You can see the numbers per year, the average per year being issued under the Bush OSHA, under Obama's OSHA, and then for the last 6 or 7 months under Trump's OSHA. All right, last thing here, fixing OSHA's VPP program. We have seen OSHA issue it's broadly styled as a request for information, looking to make changes. They're seeking public comments on what they can do with the program to make it better. They're looking for, it's really a broad request. So there's a lot of opportunity if you have some opinions or thoughts about how to make the VPP program better. The administration is listening right now. You have a window for submitting comments for about the next 30 days, 31 days. There is another stakeholder meeting coming up in New Orleans toward the end of this month. So you have the opportunity to be involved in this process. And I think this also shows something that we talked about a minute ago, more of a rebalancing toward compliance assistance instead of staying with the enforcement-heavy approach. We had received a couple of questions that we can, I'll deal with really quickly. Several were too long or difficult to handle in this context, but I can answer just a couple. First, someone asked whether, with regard to the silica rule, who postponed it? Was it the administration? Was it OSHA? When we talk these things through, generally we address the administration and OSHA as acting as one voice. We all know there may be some interesting interplay, political or otherwise, between the White House itself and the various agencies. But generally speaking, it's difficult, if not impossible, to know whether a delay of a rule comes from the career people at OSHA. Is it of their own volition? Is it at the direction of the White House, or did the White House really say, "Look, do this, or you're getting fired"? It's really impossible to know. I think that it's certain that the White House has a significant effect on things. I mean, you would see that across the entire government over the last few months. That who the president is certainly matters, but I think it's worth addressing.
Just on silica, if I could add, when I was speaking, I talked about the fact that there wasn't a political appointee at OSHA in the front office when OSHA made this determination to delay the construction silica standard from in April. However, what I failed to mention, and to Micah's point, the Trump people had in place very early on some, I forget what, there was a term for them, Amanda probably knows, but they were the beachhead team, the beachhead guys, and they had someone at OSHA who was attending meetings. I was in a couple of meetings where this person was in attendance, learning, making, I think not probably decisions on his own, but he was passing up information about these various rules to the White House, to his contacts at the White House and at the Department of Labor at a higher level. And so, certainly I did not mean to suggest that the agency of its own accord, the staff, would have taken this action without at least some interplay with the political officials who, were in place or were being reported to by the beachhead team.
All right, two other quick questions to address, and then we'll let you all go. We had a question about where do we think that things are going to go with regard to citations and fines issued by OSHA. Certainly on just the number of citations or inspections to be conducted or issued, it's a little challenging. I don't know that we have a real opinion about whether we'll see the number of citations go up or not. I think there's some indication that the number of inspections may be going up. It's an open question about whether we'll see more citations issued as a result. Another question related to, the second half of that relates to penalties. Certainly with the congressionally mandated penalty increase, that's baked in. It's going to, the OSHA's maximum penalties will move up with the the CPI, I think they're indexed to inflation. So maximum penalties are going to go up every year. Whether OSHA will use those or not, we'll all be watching and waiting to see. And then the last, I think the last one we have time for right now, related to drug testing. To the extent that it goes into the employment context, we won't address it here, but certainly the anti-retaliation rule addressed that. It seemed to call into question the ability of an employer to blanket drug test or to really target employees that had accidents or were involved, had injuries, to target them for drug testing. We'll be watching that one. I think we all probably agree that if there's any movement to be made on rolling back that anti-retaliation rule, that certainly should be a part of it.
And note that there is opportunity, I think, both in the context of the legal challenge as well as in the administrative changes. I mean, query what would happen if the Trump administration allows the litigation, participates in the litigation, but on a separate track issues a letter of interpretation that is different than what we're seeing in the guidance that was issued under this new reg. Remember, the language of the regulation itself there's no mention of drugs, drug testing, post-accident drug testing, or safety incentive programs, or late reporting. The language is very broad and very vague, and OSHA has interpreted that language to mean some very specific things with regard to drug testing, for instance. So it does seem that this may be an area where it's particularly ripe for an interpretation that is contrary to the last administration's interpretation of its own rule. And that topic itself gets into an entire new topic, but we'll have to save that one for another webinar.
That's right. All right, so on that topic, as you can see, we have a few more webinars this year. We've got a good slate set up for the fall and leading into the winter. So please do join us. You can sign up for any webinar individually or or as the series. You can sign up for that. We had a couple questions about whether these webinars are available. You should receive a link following this because you registered. You should receive a link in your email so that you can access these. As far as previous webinars, I believe we have them up on our YouTube channel. If you have any specific questions on that, or if you have a hard time finding that, please email one of us directly, and we can take care of that for you. Please check out our blog, the OSHADefenseReport.com, for up-to-the-minute updates on where things are going.
Including whether that portal shows back up on the OSHA website or not.
That's right. We'll be keeping an eye on that for you. As always, feel free to email any of us with your questions. We're happy to help you answer your questions, and your questions also help us focus on the kinds of things that we need to be talking about on the blog or the webinar. So with that, we appreciate you sticking out with us for attending. Hope to see you on another webinar in the near future. So thanks a lot. Have a great one, and we'll see you around soon.